Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
Thanks, Brad. As a business and healthcare law firm, we meet many interesting people in various stages of their business. This season, we get to focus on the high-stakes implications of selling a business. This season's theme is The Hitchhiker's Guide to M&A. We will be guest-heavy and bring in different professionals to offer their experiences and perspectives on M&A.
And for those of you who are virtually raising your hand trying to figure out what M&A means, that stands for mergers and acquisitions. And though Michael this season is guest heavy, there's a guy who's going to be joining us today. He's not really just a guest anymore. He's kind of more of a regular podcaster, even maybe. But Jay, why don't you, Jerry, you're our partners here. Jay, just welcome back to your second home.
Yes, thank you. Thank you for having me. And as you guys might hear, I woke up this morning and I sound a little off, but I promise I feel a lot better than I sound. But I got with Riley, our podcast producer, before the show, and she promised me that in post-production, she was going to make it so that I sound like James Earl Jones the rest of the episode. So,
Nice.
All right, so Riley, all right, we're going to test this out. Ready? All right, here we go. Brad, I am your father.
That's not bad.
Good, Riley?
Yeah,
All right, good.
I like it. Well, Michael, before I actually jump into, I just want to make sure everyone understands when we talk about mergers and acquisitions, we're actually still talking about this simply the buying and selling of businesses or buying and selling of substantially all the assets of business. But Michael, Jay kind of kicked this off, and I'm kind of excited. It's been too long since we had movie talk on the show.
I see exactly what's happening here. First of all, you knew that I would give you a hard time to go movie talk. So you brought Jay in at the beginning to go movie talk, and now I'm completely ganged up on. Okay, well, Brad, I guess I've got Riley on short notice to cut you off, but I guess keep going.
Riley, believe that order. Do not listen to anything that Michael says. Michael, a lot of times you make fun of me because you think I'm living the 80s, but today we're going to get more into some more modern movies and movie talk. We're going to go to the 90s. So, Michael, have you ever seen the movie Pulp Fiction?
Well, of course, Brad. That's one of my favorite movies.
Yes, it's one of mine favorite too. Audience members, since Michael loves context, those who don't know what we're talking about, Pulp Fiction is a movie that Quentin Tarantino was the director of, and it kind of chronicles a story of these different crime incidents in Los Angeles and following some mob hitmen, which is Samuel Jackson and John Travolta, some boxer named Bruce Willis, and a pair of diner bandits, Amanda Plummer and Tim Roth. Michael, when you saw the movie, did it just blow your mind from a story and then storytelling perspective?
Well, yeah, first, I have to say, this is one of the most quotable movies ever.
Yes.
With some of the most memorable characters. So when you started talking about this, instantly I'm thinking about the wolf,
Yes.
the gimp, Zed.
Yes.
Zed's dead.
Zed's
and
dead.
it's so forever emblazoned in my brain. But yeah, I mean, of course, the storytelling was incredible.
Yes, some incredibly great lines that I know we throw out with my friends all the time. I thought it was brilliant. Jay, one of the characteristics of this movie that the people love so much, and it's not the first one to do it, but it really jump-started again, was this non-linear narrative, the way the audience gets to experience. It's basically skipping around while telling a really cool story, but it's not, in a solid from A to B. It jumps from A, B, D, Z, F, Z. So it's a different experience. And you love movies, too. Obviously, we started off with a little Star Wars reference. What is one of your favorite non-linear movies of all time?
So I'll go a little bit further in the future there to the year 2000.
Yes.
And one of the first Christopher Nolan movies was Memento. It's one of my favorites, and it drops you off right at the end of the story, and it works its way bits and pieces all the way up to the actual point of the story. And so it's a non-linear story. It's fantastic storytelling. It has black and white and color, and they represent different time periods, and it's great. So, Michael, have you ever seen Memento?
I have not. It sounds way too smart for me. But no, believe it or not, I haven't seen it. I've heard of it and heard that it was a great movie. You guys are talking about this kind of these unusual movies with the nonlinear format. The first movie that pops to mind for me, and one of my favorite movies, is The Usual Suspects.
Oh, man. Michael, I'm so proud of you. That's such a classic movie. Actually, my wife, Mike, and I, it's one of our favorite movies, too. And other people, when you start talking about great nonlinear movies, you might throw out Reservoir Dogs. Some people think that's one of the best ones. Another Quentin Tarantino movie. Talk about classic movies. So I'm going to go way back in time. Citizen Kane is another one. So no matter whatever is the quote number one nonlinear movie of all time, all these are amazing because they're great stories, great movies, and then you don't seem to be able to understand where you're going to start or end. And for those audience members who are listening who love this movie talk, just understand, go your Blockbusters and rent the movies that we're talking
Oh,
about.
Brad. You truly went
90s.
back to 1990, yes. So
No more Blockbuster?
I'll confess that you guys successfully sucked me into the movie talk. That was interesting, but I think we are not trying to go so far as to be a movie review show, or at least I would like to keep it from that, Brad.
Okay.
So let's kind of go with legal talk. I think the listeners that are still with us probably came on to hear something along those lines. So where are you going with this opening banter?
Well, besides Jay doing his Darth Vader impression before we started, understanding some of the story that Jay's going to share, it reminded me that when a client gets involved in an M&A deal, or actually any legal arrangement, they sometimes just want to jump to the end, and they skip around to get there, and that works really well in these movies we were just talking about, but it doesn't always work really well in legal structures.
Well, cram that segue in there, Brad.
You're welcome. Well, all right. Now, before we get into Jay's story, context man, Mr. Michael, why don't we just take a little brief reminder of our audience of what's going on right now. We're talking about the seasons of businesses and really focusing on the 5 phases of an M&A deal. So just give a quick recap, please.
Yeah, and as we've talked every show, the M&A deal is really a buildup of what's happened in the various seasons of a business, and all businesses are in what we say are one of 4 seasons: the building season, the operating season, the scaling season, and then finally the buying and selling season. And so when we get into the buying and selling season, that's of course primarily what we're talking about M&A, and we talk about this kind of timeline in an M&A deal, or the 5 phases of an M&A deal. There's the kind of the beginning, and that ends with the letter of intent, and then you get into the due diligence, your underwear drawer moment, Brad, and then we get into the definitive agreements, the drafting of legal documents and negotiations of those documents. And then we pop the champagne and have a closing. And then, what people don't like to hear is there's a bunch of stuff you have to do post-closing to clean things up.
Good job, Michael. That's perfect. We're so proud of you. Now, Jay, which of these phases are we going to focus on today?
I guess technically the closing and post-closing phases today.
I like your strength in that answer, by the way. So every client, the deal, they love to see it just close. They love to hear the deal is closed. And rarely, really do they care about, what happens post-closing. And Michael, you have been a lawyer forever. I think, 1900s is, I think, when you got your first doodle.
When Citizen Kane came out.
Yeah, when Citizen Kane.
Yeah.
Will you give a little, again, context from our audience, understanding that, what do we say closing and post-closing phases, for those who aren't familiar with it, just kind of give an idea what that looks like, and don't really talk about your speed typing as you're talking about closing.
Oh, okay. Well, I guess I'll stay away, but yeah, the closing, back in the day probably did involve some typing, but unfortunately, that wasn't able to utilize that skill set for that.
Your ink pen.
In modern times, the closing is, kind of the culmination and finish, official finish of a deal. And that's, generally speaking, documents get released, funds that are involved get transferred, celebration ensues. And so, it's kind of a very small moment in time relative to the entire phase, because it's all done virtually. And so, you get to a closing date and there's a mad rush up to that in the days leading up to the closing. And then it happens. And then, there's a little bit of kind of that air of pressure of what now, it's all that work is done. And then, you realize that you got to clean up all the stuff that everyone decided, okay, we'll do this post-close, we'll do that post-close. And so, there tends to be a lot of, kind of corporate cleanup that happens after the close, and sometimes some compliance-related cleanup that wasn't dealt with, and then just some administrative closing binders and that sort of thing.
Sounds real exciting, that post-closing part. Now, Jay, what story do you have today, I guess, that's going to kind of line up with what the post-closing and closing aspects of it?
All right. So, today's story is going to involve a client who we're going to call today Skippy. And the story begins on the last day of June when Skippy called me up and said, hey, I agreed to sell my business. And oh, by the way, the deal's effective July 1st.
Oh, wow. Well, and first, Skippy sounds like such a boyish, innocent name, and yet you just told me about your one-day notice phone call. I have a feeling I'm very wrong about this impression.
Well, first off, Riley, please save that, because Michael saying that he's wrong is not said enough. Mm-hmm. So that's correct. You are wrong. Now, Jay, how long have you been working with this client to get this deal done? Since obviously there's an LOI phase and due diligence. So what point did you really kind of get in there?
Yeah, the phone call.
Oh.
when I picked up the phone and I heard the news.
Okay.
Last one in the party.
So this was one of those cases where the client had been negotiating the LOI and the parties were doing the due diligence, but just no involvement of you?
Yeah, I mean, basically. So what I gathered from my conversation is, Skippy and the buyer had formed a general business connection, spent time talking business, nothing very specific. They'd known each other for a while. Maybe at some point they had high-level discussions about general ideas of what of a sale or purchase would look like, but I never heard anything, and there was nothing formal. And so I actually had no idea that a sale was even being contemplated by Skippy until that day. I got the call.
This is red season, the red flag season. We probably would have the ding button going a little crazy throughout the story so far, but we're going to move on. But audience members that didn't understand, these are not good signs on how a deal can progress successively. So what did you learn about what was going on with the deal, Jay?
Yeah, so what Skippy told me was that he and the buyer met that morning, and throughout the day they worked out all of the details that you ever needed to work out. All of them. Yeah, okay. They covered everything. And they even signed an MOU outlining everything and signed it and said it was effective July 1st. Okay,
well, we're just throwing out all these slang terms, M&A and other things. So, Michael, context-wise, Jay just said, what is an MOU?
Well, first, let me just clarify. Did you mean they signed the MOU on the day that they called you?
Yep.
Oh, okay. So it was effective the next day. Okay, well, so an MOU is a memorandum of understanding, and it's closest, akin to a letter of intent. So it usually is, here's the concept of what we're agreeing to. And so there's nothing wrong in of itself with signing a memorandum of understanding. It is a little concerning when you get the call and then everything's over the next day, because that's usually kind of the tone-setting beginning of an M&A deal.
If we're going through the 5 phases, that is phase 1, audience members, of many.
Yeah, so in this case, they were basically treating the MOU as if it was the definitive documents. So I said, "All right, Skippy, send me the document. Let me take a look at it. Maybe you work some magic and it's not what I expect, but of course I get it. It looks like an LOI. It's has some high level terms, but it did not at all deal with everything that you typically see in definitive agreements. It was just basically a summary of, here are some of the things that we're going to do, but it didn't have any of your typical provisions you see in those type of documents."
All right. Well, it sounds like you had a lot of work cut out for you. So what did you end up doing?
Well, so I jumped on the phone again with Skippy, and not only to talk about the MOU in general, but I basically spent the entire time explaining the 5 phases that Michael just went through, trying to, show them technically we're only in phase 1. We haven't really done anything. And if they expected that due diligence and the definitive documents phases were going to be done in less than a day at that point, just not going to be feasible. And there hadn't been done any due diligence. No one's looked at anything. No one's asked anything. CPAs weren't brought in. There's just nothing done. And so I was basically just sitting there trying to convey, hey, this this isn't even close to closing the deal tomorrow. This is just the first step, and let's start from there.
And how did Skippy respond?
Well, of course, at first, he was all gung-ho about the deal being closed and selling the company, so he was resistant. But then, as I kept explaining why there were needs to deal with it in the proper way, and I started asking questions about, okay, what about taxes and credit cards and liabilities that weren't talked about in the MOU that I knew about? He started to come around and understand, okay, I get it. And by the end of it, I was, asking what if scenarios. And I think it became clear towards the end, okay, I got it, that maybe we don't need to just expedite this tomorrow.
Okay, well, did that help?
Well, for him, yes. I mean, we left the conversation. I felt great about it. Skippy was like, "Oh yeah, I get it, totally understand." The problem was the buyers thought, "No, this is the deal. We closed it. We signed it yesterday. We worked all day. It's effective July 1st. We own the business." And so to the buyers, no, it was a done deal.
Jay, this is kind of straightforward story. Someone sits down with someone, writes a piece of paper, they sell it. But I thought you said we're going to really focus on the closing and post-closing.
Yeah, well, so because the buyer didn't agree and didn't really understand that, I mean, we basically were consummating the deal as if it was owned on July 1st, and we were, at the end of the day, turning and doing the definitive documents during the post-closing phase. So again, kind of backwards, but that was the best we could do at that point because everyone was very steadfast. No, this deal closed July 1st.
It is starting to feel like the Pulp Fiction of M&A deals. So what did you do?
Well, so we talked about all the missing pieces. We talked about the things that needed to be dealt with. And I talked to Skippy a lot about, the risks of, hey, if we go this route, there's a lot of risks of things that if we don't do, it's going to be problematic.
Well, hopefully that changed something, right?
No, not at all. They were okay with putting the definitive documents together after the fact, but they weren't going to do any due diligence. They had done everything during that meeting. The effective date was still July 1st, and they actually wanted the MOU to become part of the agreement somehow because they had negotiated it and they had signed it. And so again, we were going back to the 5 phases. We were going to develop these definitive documents after closing occurred during the post-closing phase.
Just like they draw it up. Well, so what ended up happening?
Well, so as you can imagine, we go through the definitive documents and things hadn't been addressed, things haven't been asked or questioned. And so every time I had a question that wasn't covered, this would kick off basically new negotiations at this point between Skippy and the buyer. Sometimes it would be a quick conversation and I'd get the answer right away. Other times it would drag on for days because they couldn't agree. And, spoiler alert, they didn't talk about it during that day. But ultimately, they wanted the deal just to get papered up. So it kept moving forward. And we finally did get the documents all prepared, everything signed off. But that's, bigger issues were still to come.
Yeah, so audience members, you're probably guessing already the things that weren't covered by the MOU probably caused some trouble.
Wow, how could you ever have guessed that from that story? So yeah, about 2-3 months later and beyond, things started popping up from Skippy's ownership time frame, but they were now, coming after on and affecting the buyer and the business. And so as you can imagine, buyers saying, "Hey, Skippy, take care of this. This is your fault." And Skippy's like, "Nuh-uh, it's yours. You took it." And so it became, discussions and more negotiations and more issues. And you look at the general MOU to figure out, okay, well, what did you guys agree to during that all-encompassing meeting? And there was nothing there. So it that was not helpful.
I'm guessing that most of our audience could see this train wreck coming. That's impressive. Well, let's go to break and talk about some of the lessons to be learned from Skippy's story.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to the Legal 123s at ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd, and series regular, Jay Riero, still all here. Now, Michael, we just had a heck of a story on Skippy, huh?
Yeah, no kidding. Skippy was not the sweet, innocent boy that popped to mind. Well, maybe he was
very
naive.
innocent.
Yeah.
Naive, yes.
But so, yeah, here's the story. Jay gets a phone call on June 30th saying that he has a deal. His client has a deal, Skippy, and they're closing the next day. And so as Jay starts to unpack that, realizes that they did that day come up with an MOU, which in of itself is not bad. I mean, we've had episodes where, there are issues that go with that as well.
Sure, yeah.
But it's not the worst thing. It's non-binding, as they say. And at least you can launch from that and hopefully fix some stuff. But lo and behold, Jay discovered that they view this as the definitive document. So this memorandum of understanding was actually in their mind the paper that closed the sale of a business. And so Jay, though he tried his best to explain the 5 phases of an M&A deal, the buyer in particular wouldn't be moved, and so Skippy went along, and they decided to do things backwards and have sold the business and then paper it up after the fact. And where we left off was trouble brewing months later.
Yeah, and so, I think one of the biggest mistakes here, we talked about at the beginning, nonlinear is fantastic for movies, not so much for the M&A process.
Right.
Because the M&A process, the 5 phases Michael talked about, are there for a reason. They each serve very important purposes. The LOI establishes expectations. The due diligence uncovers hidden issues. The definitive documents, memorialize everything. And the closing is kind of that final chapter of we're done. And then post-closing is let's clean up the things that we knew about beforehand. Mm-hmm. And so, not going through that process and just kind of skipping ahead and starting at the end, really creates massive issues, especially because there's less than 24 hours to have the deal technically done. And so that was, you can see how that nonlinear situation and not understanding the process can really be problematic.
Yeah. And, we're blessed to have a lot of entrepreneurs and physicians we get to work with, and they're super smart individuals and extremely knowledgeable in the field that they're in. But often the case is that makes them their own worst enemy, is because they're the smartest person in the room. They think they can figure certain things out, which they might. But they think, well, I don't really need – I've actually been in a room on a panel where someone's like, you don't really need an attorney to do this stuff. You can negotiate everything yourself, and there's no reason to have them in. And maybe that particular – and it was a doctor – was correct, but I'd love to see what happened with the definitive documents. I'd love to see what post-closing obligations that they agreed to, and whether or not they're within the margins. And so not for audience members to understand, I'm not saying you have to hire an attorney. You just have to understand there's so many different phases to a deal to be done correctly. And you really do want to work with someone that has the knowledge to have done these deals. And audience members, you're probably going to roll your eyes when you hear me say this, but we always talk about the 550 rule. This is a perfect example of someone who's like, oh, I'll just do it right now. We'll get this deal done. And it's only, but they did not realize on the back end that's going to cause tremendous pain and issues because of a date that they had to meet, that July 1st date, within 24 hours of signing it. And so the 550 rule, you'll pay $5 up front to do it right, or $50 in the back end. And this sounds like starting to fall into the $50 rule.
Yeah, and just to add on to both of you guys, we kind of talk about the purpose in past episodes of the LOI, that it sets the tone for the transaction, the purpose of the due diligence phase. We had a lot of conversations about that. But if we just take a step back from each isolated phase and ask, why do we go through these 5 phases, it really comes down to 2 things. One is risk management, and 2 is expectations. Mm-hmm. You have to get to understand what are the risks with this business and who's the one that's going to be responsible for that risk, the buyer or the seller, and then getting on the same page on expectations. So many times these M&A deals end in some form of a partnership. They're going to be working together in some way, and if they're not aligned as to how that's going to work, there can be trouble ahead.
Yeah, and I think the other thing that we kind of see too is if you go really fast, you don't uncover a lot of things that could lead to a delay. There's permits and accreditations and licenses and contracts that need to be assigned, or you need to apply for new ones, or you have to go to a third-party landlord and request consent. And those things get out of your control, and if we don't deal with those early on, that can sometimes delay closing, weeks, months. When we've seen it, significantly long period of time. Everyone's ready to close the deal, and yet we can't technically close because there's someone out there who has to be a part of the process that we didn't involve early enough. So, not going through the process creates that risk that that's going to happen at some point.
Yeah, and Riley, you can cut this, but Michael had a good point there. Is that alignment of expectations is really what that LOI is should do, or in this case, the MOU. It's just trying to figure out, are we aligned, and what are those? And we've talked about this probably in other episodes. The reason why we talk about the 5 phases, there's a process, and you have to understand you need to trust that process to be able to go through each phase, and each phase is extremely important to the next step. And as Jay was alluding to, because during each phase you might learn about something new, and then you're like, oh, wow, who handles this particular obligation? I don't know. I thought you were going to handle it afterwards. Well, let's figure that out, because that's an important element to the post-closing. Your other point that Jay made was really important, especially in healthcare deals. A lot of times you'll say, oh, I want to go buy this pharmacy and move it from San Antonio to Houston and just buy the license. You're like, well, that's not how it works. And so a lot of they've negotiated and discussed it, and then you realize it's not a transferable asset. So those are the reasons, again, especially in healthcare deals, you want to start kind of bringing those experts in to help you through that process.
Yeah, and you mentioned earlier, and you're being a little bit, humble, as you like to be, Brad. And you're like, I don't know that I'm not saying you have to have a lawyer for this. And I kind of am like, well, yeah, actually, for an M&A deal, you have to have a lawyer for this. It's like being going and operating on yourself, and instead of having a doctor do it with less stakes, you're not going to die, obviously. But my kind of taking your expectations point, Brad, there are so many parts of a business transaction that business people, there's no way they could know that they even need to talk about it.
Yes.
And that's where it gets super complicated, and you have to have an expert that can walk you through, kind of like what Jay was trying to do after the fact.
Yes.
But
all within 22 hours or whatever it was.
Yes, exactly. And so you have to know what to talk about to even get alignment. An MOU hits the big points, but isn't going to hit all the points.
Yeah. Well, Jay, I guess audience members out there are probably wondering, what are some, besides your final thoughts, but what happened with Skippy and the buyer?
Well, to no one's surprise, for the next probably 12 to 18 months, these issues that were never addressed during that day-long meeting kept popping up. And it became an issue because at some point, the buyers were fed up with all these random issues that they never knew about popping up, and they weren't going to take care of them. And yet the seller was like, hey, this is affecting me. I need you to take care of them because you promised. Threats of litigation. There was a lot of fighting. Some things were just kind of, dealt with, and some things weren't. And so it was a mess for, 12 to 18 months before finally, I think some of the stuff, pre-Skippy finally kind of stopped.
Yeah. Well, makes sense that that 550 rule probably came into play. Michael, what are your final thoughts?
Well, I would highly recommend don't go the route of Skippy. You don't want your Jay to be playing the role of the wolf in your M&A transaction, and you certainly don't want Brad playing the gimp.
Well, audience members, hopefully you didn't throw your earbuds out of your ears, but that is all the time we have today. Next Wednesday, we will continue our journey on the Hitchhiker's Guide to M&A. We are going to turn our attention to the impact that the Sensei plan has on an M&A deal. Thanks again for joining us today. And remember, if you like this episode, please subscribe, make sure to give us a 5-star rating, and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.